If you are selling a home and think you do not need to disclose the mold issue you had 10 years ago,
where we'd have mold, they would collapse when I go like this.
Or your issues with your noisy next-door neighbors.
It's our sorority.
What are we gonna do? Title buyers are not gonna want to live next to a house with the sorority in it.
You are probably wrong and may even find yourself in a legal dispute with your buyer. Stay tuned until the end of this video to learn how you may be able to avoid such a sticky situation. Today we are diving into an important aspect of the sale process and will be sharing information regarding a seller's disclosure obligation in California. A seller's failure to disclose material facts about their property during the sale process is one of the most common reasons for real estate disputes. While buyers are always advised to conduct inspections of the property, California law specifically requires sellers of residential real estate to disclose material items about their property prior to closing. Since 1987, sellers of real property containing 1 to 4 residential units have been required to complete a real estate transfer disclosure statement, or a TDS, per California Civil Code, as the method to fulfill this disclosure obligation. In addition to the TDS, there are 2 other forms used by the California Association of Realtors which help a seller fulfill their duty to disclose. These are the Seller Property Questionnaire and the Exempt Seller Disclosure. Let's dive a little deeper into when a seller is required to complete a TDS versus when they may complete an exempt seller disclosure. In general, the statute requires that a TDS be filled out by sellers of residential 1 to 4 unit properties, but there are a number of exceptions, including but not limited to the following: REO and foreclosure sales, probate sales, bankruptcy sales, sales by government entities, that portion of a mixed-use property not constituting residential 1 to 4 unit property. In addition, sales by a trust may be an exemption. However, if the trust is revocable, the trustee is a natural person, and the trustee was either a former owner or has lived in the property during the preceding year, they are actually not exempt. While these are legal exemptions, misidentifying a TDS exemption puts both the seller and the agent at risk for potential liability. Such a mistake may cause a seller's breach of the law or even breach of the purchase agreement. Even in circumstances where the seller knew little about the condition of the property, failure to deliver the required TDS provides the buyer with an ongoing contractual right to cancel the sale, even if the buyer had already removed all of the buyer contingencies. So, what are some of the common misconceptions regarding exemptions from disclosure obligations? Each of these so-called exemptions are illusory because there is no legal basis behind them. The first misconception is an exemption because the seller does not occupy the property or lives out of state. Completing a TDS does not depend on whether the property is occupied. There is even a box on the first page of the TDS that a seller may use to indicate that the seller does not occupy the property. Likewise, it makes no difference where the seller lives, whether Arizona, France, or Africa. They are still required to fill out the TDS when selling a property in California. While the seller is required to complete the TDS, it is important to keep in mind that a seller does not have an affirmative duty to investigate or conduct additional research when completing the document. In general, the TDS is based upon information that the seller actually knows. The second misconception is a flipper or investor exemption. Again, knowledge about the property or lack thereof is not a basis for any TDS exemption. Furthermore, often when a flipper says that they do not know anything about a property, it's actually not very credible, as flippers are professional purchasers who've likely done extensive research on the property and made improvements. The next misconception is the waiver by agreement exemption. The TDS emphatically cannot be waived. This is stated in the first section of the TDS law. Even if a buyer tells a seller that they agree to waive the TDS, it makes no difference because such a waiver is absolutely not enforceable. The next misconception is the as-is exemption. Often a seller who is selling the property in as-is condition mistakenly thinks that an as-is sale creates an exemption from making disclosures. but that is simply not the case. As is only means that a seller has no obligation to make repairs to the property. It does not affect the duty to make disclosures. The next misconception is the for sale by owner exemption. Whether or not a seller employs a real estate licensee has no bearing on the obligation to fill out a TDS. Thus, a seller acting on their own is still required to make all disclosures, even though they may not even be aware of this legal obligation. Another misconception is the teardown exemption. Don't be fooled by this one. It may seem that if a buyer is going to tear down the structure, then making disclosures about its condition is irrelevant. However, in reviewing some of the questions on the TDS, you'll notice many of the questions concern conditions affecting something other than the physical condition of the structure itself. For example, question C11 asks about neighborhood nuisances, and question C2 asks about features of the property shared in common with adjoining landowners. These items are relevant even when a buyer is planning to tear down the structure. In addition, just because the buyer currently plans to tear a property down doesn't mean that they don't need to know about existing issues. For example, if the seller is aware the property contains asbestos, this is important information as there is likely specific remediation or abatement required prior to tearing down. And of course, there's always the possibility that the buyer could change their plans for the property. Regardless of whether or not the seller is exempt from the TDS or SPQ in a transaction, they are always required to disclose all known material facts regarding the value or desirability of the property to a buyer. For example, an exempt trustee may have specific knowledge of a material defect such as a leaking roof and would be required to disclose that information to a buyer. In the cases where a seller is exempt from providing the TDS, there is an exempt seller disclosure a seller may utilize in order to fill their obligation to disclose. When completing disclosures as a seller, and you find yourself asking whether a particular disclosure needs to be made, the answer is almost always yes. Think of it this way. If you don't want to disclose a piece of information about the property, look at your reasoning for why you do not want to share this information. If the answer is because you think a buyer will not want to purchase the property, or they may want to negotiate a lower price, this is exactly the reason why the information should be disclosed. It is information which materially affects the value or desirability of the property. We hope this information was helpful to any sellers watching, and as always, please reach out to any of us at Coastal Estate Group if you have questions or would like more detailed information. We'll see you next time.